We've been tracking, obviously, for your all's purposes and for our purposes, different bills that affect creditors' rights, that affect real estate, auto lending, and other finance issues, and then just other general recording issues that we'll get into here in just a second. I will make a quick plug for Rick Vance, who's out of the office today. He's in Jamaica, so I don't know if he's having more fun or if we're having more fun here today. But he did publish a creditors' rights sidebar blog post the other day, just kind of commenting on where things stood as of last week with respect to some of the issues I'll be talking about here in a second. And at that point in time, there were only 3% of the 941 bills that were introduced in the House and the Senate that were actually signed into law at that point. Thankfully, despite the budget discussions and everything, there have been a lot of increased passages and bills that were signed into law over the past week, and so there has been some other activity that I'll be discussing here in just a second. I will say it's going to feel like I'm kind of jumping around just a little bit because a lot of the changes that affect those of you in the room and our practice, a lot of these changes are not going to be a lot of whole-scale changes. One of the things we discussed last year, and I'll make a brief remark on, is we were discussing the possibility, Kentucky's a judicial foreclosure state. And between our various offices, some are judicial, some are non-judicial states, but Kentucky, the Commonwealth here, is a judicial foreclosure state. And there was discussion last year, which would have been a huge change here. It would have completely affected the way that we do business on the foreclosure side. There was discussion of a bill, and there was a bill introduced to change Kentucky from judicial to allowing the opportunity for non-judicial foreclosure. There was a lot of back and forth between bankers associations and consumer advocates, and that bill was not introduced this year. And so I don't have any big, sexy reports to change. It's going to be kind of getting into the weeds about some technical things here and there. So I'll go ahead and just get right into some of those details. So the first actual 4 slides that I'm going to talk about, they're all concerning Senate Bill 122. And so these are all kind of fall under the category of recording issues, whether it be certificates of title or whether it be real estate recordings, mortgages, deeds, etc. So the first change is just a change in the perfection for any motor vehicle or boat. In Kentucky, also kind of a quirk in our state law is that trailers or manufactured homes are actually titled personal property as well. And so if it's not been affixed and made part of the real estate, then a trailer or a manufactured home is actually, the way you take a lien on that is on the certificate of title. And so this is, again, a technical change, changing the perfection period, the effectiveness from 7 years up to 10 years. But as you see, with that, the continuation statements went down from 7 years to 5 years. And that's counting from the date the existing lien would have expired. And so, for example, say you have a lien that was noted on a certificate of title on a motor vehicle, and you have an expiration that expired April 15th, say tomorrow. 2016. So this continues to keep continuation statements such that if you file that continuation statement within 6 months of the expiration date, in my example tomorrow, if I would have filed a continuation statement March 1st, then the effectiveness of that continuation statement continues to operate not from the date that I filed the continuation statement, but from the date that the original lien would have expired, but for that continuation statement that continues it on. But again, it's a decrease in the effectiveness of that continuation statement from 7 years down to 5 years. Also, just this is more on the real estate side. A very, very, very technical change in the sense that this was literally one change to the statute, one word change, I should say. It literally just drops the word next. And so what this means specifically is that this part of the statute states that the clerk in the county clerk's office where real estate liens and mortgages and deeds are recorded shall not record a lien or mortgage unless the deed or conveyance refers to the immediate source of title. And so this statutory section used to state, or still does state until the effectiveness of this bill, the next immediate source of title. And so there was some confusion with some in the space. Does next immediate source of title mean the preceding source of title, or does it mean the immediate source deed? And what's intended is a reference to the immediate source deed prior to the existing mortgage or the existing deed. And so this is just technical change, just to clarify and be more precise that we're actually referring to the immediate source deed and not the deed earlier in the chain of title. So, and feel free to stop me at any point, because as I'm talking about some of these things, I do fully appreciate that some of these changes, without the full statute or without some context and everything, may be hard to appreciate. So feel free to stop me at any point. Go ahead. Thanks. Another technical change, as I mentioned before, Kentucky is a judicial foreclosure state, and so what happens at the end of a foreclosure is there is an actual deed that is conveyed from the Circuit Court Master Commissioner, which is the office that conducts judicial sales in the Commonwealth, and they take all of the interests that anyone had in the foreclosure, or anything preceding the foreclosure, I should say. So any lien interest, any other encumbrance, and they transfer any of those interests to the successful purchaser at the sale. So if you're a bank credit bidding at a foreclosure sale, or if you're just a third-party purchaser, that interest is being conveyed by the commissioner's office, who's conducting the judicial sale, and conveying that interest to the successful purchaser at the foreclosure sale. And this is just a technical change. Previously, there was no specific time frame requiring that conveyance to be recorded within any specific time frame, and so there was some concern from consumer advocates, and I don't know of any particular reason why this was an issue, honestly, but there's now an express requirement that deed of conveyance from the commissioner's office has to be recorded within the county clerk's office within 5 business days of receipt. So again, just a technical change to be aware of, and especially if you're operating in the Commonwealth and you are purchasing properties at foreclosure sale, which is quite common with a lot of our clients. Sometimes banks have no desire to own real estate. I understand a lot of you probably are not in the business of wanting to keep property in your portfolio, but to the extent that you have that as part of your business practice, just be aware of this technical change.
And I'll jump in, Brian. We've had a lot of problems come up lately in our office in terms of litigation with property taxes and code violations, especially in Louisville. So the owner of the property is usually a securitized trust, so I'll say Wells Fargo Bank NA as trustee for XXXXX, and so they're the owner of the property, and they're getting these tax bills, someone's buying them, and then they're getting sued, and we don't know how to get these things paid, we don't know how to deal with the code violations, and the bank wants absolutely nothing to do with it. And then, Wells Fargo, we may have a contact with them, but they're really just the trustee, and then someone else is servicing it. So this may be part of that problem, and it'll be interesting to see where that goes, because I'm seeing it more and more, so maybe we'll report on that next year.
Okay, and then this is the last bill or the last portion of the bill, I should say, section on Senate Bill 122 on the recording piece. Again, just one final technical change. So in Kentucky, attorneys are allowed to record affidavits of amendment to correct clerical errors and omissions in recorded mortgages. And so this statute, it's literally just adding some words so that the statutory scheme is not confusing. It's clarifying that those affidavits may change the terms, the dollar amount, and the interest rate with a signature by both parties, the grantor and grantee. But you cannot change, and this was already part of the statute, you cannot change the parties or the collateral. You can't get some unfair benefit over other creditors who may be claiming an interest in the property. But you can change manifest clerical errors and typos. And so this is all made part of the statute just to clarify the effectiveness of how an affidavit of amendment can be used to clarify what the interest in the mortgage, in a recorded mortgage, was supposed to be if there are such clerical errors. So moving to Senate Bill 74, this allows the secured party to have the county clerk from another county fax a termination statement for a discharged security interest and a certificate of title. Previously, the secured party, the normal way to go about discharging a lien that's notated on a certificate of title is to deliver an authenticated termination statement to the clerk's office, and then they'll have the lien removed from the certificate of title. So this, again, I honestly don't know the background. It seems like this change is more of one for convenience, but the change here is that you can go to, if I live in Jefferson County, but I have a lien that's stated in Fayette County here where we sit in Lexington, then I can contact the Jefferson County Clerk's office. They can send an authenticated statement on my behalf to the Fayette Circuit Clerk, and they can have the lien removed there. And it gets somewhat technical, and so just take a look at the statutory language in that bill. Again, I don't know that it's going to be a major overhaul in terms of practice, and most people will probably continue to follow the earlier procedure, but something to be aware of. And there's also a provision that's added to hold clerks harmless for any fraudulent termination statements that are recorded, so long as they do their due diligence to verify that that is a proper termination statement. And so just decrease liability on behalf of the clerks themselves. For any auto lenders in the room, there is a slight improvement in terms of how much time you have to perfect your lien on it says motor vehicle. I should include the other categories that I was discussing earlier: motor vehicles, boats, trailers, manufactured homes, anything that's subject to a certificate of title. You now have 30 days to perfect that lien from the date of the security agreement execution, as opposed to 20 days, which was the prior statutory language. And then finally, before I turn it over to Katie, just a couple of other bills of interest just to be aware of, and I won't go into much detail on these, but Senate Bill 97, it was an act relating to mortgage loans, specifically anyone in the business of mortgage loan companies and mortgage loan brokers. And so there were some technical changes that were introduced during the legislative session. This, when I last checked, and like I said, this is subject to change up until tomorrow. This was not signed into law yet. Still may be. So just be on the lookout for that if you work with or employ mortgage loan brokers and others that are licensed in the mortgage loan space. Senate Bill 118 is an act relating to money transmitters. So this is just adding additional exemptions to the application of the Money Transmitter Act of 2006. And this is specifically applicable to money transfer services such as Western Union, PayPal, and others. So just be aware of that. It's, again, just a very technical change, may not affect many of you in the room. And then finally, Senate Bill 120. This is an act relating to bank officers, and this is making a change to the potential liability of bank officers and bank directors. And there used to be, or still is, I should say, until this bill becomes effective, a specific statutory framework for the obligations of bank officers and bank directors. The change here is that it's repealing that prior statutory language and then referencing the language for the Kentucky Business Corporations Act. And so the general Kentucky Business Corporations liability for officers and directors will now be applicable to bank officers and bank directors. So something to be aware of internally and maybe talk with your boards about and other officers at your respective organizations. In terms of, I think that does it for me for now, but in terms of the effective date, so the way the effective date for any bill, unless it's emergency legislation, the way that works in the Commonwealth is that 90 days from the date of the last legislative, the date of the final day of the legislature the adjournment date. Typically, it's 90 days from that date is the effectiveness date of any date that's not specifically noted otherwise. There's usually an Attorney General opinion that specifically sets that forth. I think 90 days from tomorrow will put us somewhere into, I believe it's like mid-July. But there will be an Attorney General opinion that sets this effective date. So feel free. We did update the materials, and so I'm not sure that some of these got into your all's material. So I'm happy to discuss any of this, or at least give you the references so that you can refer back to things as needed. A lot of this stuff is available on the Legislative Research Commission's website and very easy to access, and you can kind of dig a little bit deeper into the text if you'd like. So I'll turn it over to Katie.
We do have a couple of new slides throughout the presentation, so if you are interested in them, email us, and we'll definitely shoot those over to you. It's a little bonus. We've got a little extra info. If you pay attention, you can take notes. We wanted to talk about what the CFPB has been up to since we were last here in 2015. Of course, it's impossible to talk about everything they've been doing over the last year, but I wanted to talk about things that I think may be important to this group or might be interesting. This is I love this little slide because I think this is probably what your compliance officers feel like, because their hair's on fire and things are changing so quickly. I feel that way sometimes, and I don't do compliance every day. One thing that I thought might be helpful to talk about, especially for some of the banks in this room, are the changes to what is a small bank or a small creditor according to the CFPB. And this is very new, actually. So in December of 2015, the Congress passed the HELP Act, which is helping expand lending practices in rural communities, which really redid some of the CFPB's regulations. Congress said, no, we don't like that, so we're going to change it. And they've essentially changed what it means to operate in rural or underserved areas. So the CFPB, after Congress passed the HELP Act, issued a final rule, and it's actually an interim final rule in March of this year, and it allows 30 days for comment. But I thought this was kind of interesting because I don't think we've seen this from the CFPB, really acting in response to directions from Congress on how to handle lending issues. So before the HELP Act was enacted, the CFPB determined that to take advantage of these special provisions for a small creditor, you had to operate predominantly in a rural or underserved county or area. Kentucky, I looked at the little list on the CFPB's website, and we actually have 77 rural or underserved counties on that list. And you're a rural or underserved county if you're not located in a metropolitan area and you're not located on the cusp of a metropolitan area. So Bullitt County is not going to work. But there are a lot of places, especially in eastern Kentucky, that are rural or underserved counties. So under this new rule, if you do one loan in that particular county, you could be a small creditor and you can take advantage of certain we'll call them benefits. I don't know how beneficial they'll actually be, but you can do some things that other big banks can't do. There are other restrictions here. You have to originate 2,000 or fewer first lien loans annually, and that includes your affiliates. So I know that's going to take a lot of people out of that bucket. And you also have to have assets of less than $2 billion a year, and that is that changes. And so right now it's $2.06 billion. So if you are a small creditor, I'll tell you what you can do now. Interesting, there's a look back period here. So say in 2016 or 2015 you were a small creditor, in 2016 you're not going to be. Well, does that mean you have to change everything on January 1st, 2017? Because that's going to be really hard to do if this is part of your lending platform. And the CFPB will allow you to get to April. So you can take applications up until April 1st of that year, and then you've got to change. So if you've got to change in your small creditor status, you have a little bit of time to make some changes so that you can comply. If you are a small creditor and you fall into this bucket, you can do a qualified mortgage with a balloon payment. For those of you who are not familiar with qualified mortgages, they're awful. In 2013, under the Dodd-Frank Act, the government decided that banks should make sure that customers have an ability to repay their loans. And there are a couple ways you can do that. You can go through all these factors to say, yes, they have the ability to repay, and they're very detailed. I've had a lot of clients run into problems if they've got farmers, because their income's a little bit different. It's not all at one time. It may only be once a year. Or you can do a qualified mortgage. And a qualified mortgage is basically a product that doesn't have these inherently risky features like a balloon payment. We have a lot of clients, especially in Kentucky, who do balloon payment loans for their customers. They've always done it. It's been part of their program. Now you can do a qualified mortgage with a balloon payment if you're a small creditor. And they want to make sure that the big banks aren't clever and split up all their little entities so that you can take advantage of the small creditor status. So if you do one loan in this area, now you can do qualified mortgages with balloon payments. And I thought that might be interesting to some people here. If you're a small creditor, you can do a high-cost mortgage with a balloon payment. I don't have many clients that intentionally do high-cost mortgages, but if you do, this is something that you can do now. And also, if you have a higher-price mortgage, then you're not required to have an escrow account. There were some changes in the rules that were supposed to take effect on April 1st, which is why the CFPB fast-tracked this provision. And under some of those rules that were existing, a lot of banks started the escrow account process, and so the CFPB said if you did that, you can change now that we've revised the rule and the definition of a small creditor. I thought this was interesting because it shows some reaction by Congress to challenge what the CFPB has done, or to say, yeah, we don't like that, we're going to change it. I don't know how beneficial this will actually be for operations, but it gives me a little bit of optimism, I guess, that we could maybe get some relief going forward from Congress on some of the CFPB requirements. I felt like I couldn't come here and not talk about TRID. I really like this slide. I'm sorry if people out there. So, TRID. TRID is the TILA RESPA Integrated Disclosure Act, and it took effect last year. And so, when you bought a house, you would get your HUD statement, and then before the loan, you would get your GFE. That's what we all had for years. Well, all of that's been completely changed, and I'm sure you all know this, but I wanted to refresh some of our commercial lenders who don't have to deal with it every day. Thank goodness. You should say a little prayer right now. But all this has been changed. So now the disclosures are integrated, and there's been a lot of problems with this. It's been confusing. They're difficult. They're very long. The regulations are difficult to understand. They're difficult to kind of mesh all together. And so I understand everyone's pain. I know it's hard. What I thought I would do is talk about some of the issues that some of the auditors are seeing with TRID problems, and then talk a little bit about liability. The CFPB does like a little presentation as well sometimes, the know before you owe disclosures. It's awful. I listened to it on Tuesday. I sat in on it. It's super complex. It's super difficult. I don't think they tell you anything you probably didn't already know. I mean, they really read slides word by word. There's no commentary. But they do a good job at kind of piecing all the puzzle pieces together. And so I would recommend all compliance people to look at that, listen to it. Maybe it'll give you a little bit more insight about things. I'm actually going to have our word processing team dictate that so that I can search flood insurance when these issues come up, because they're very complex and it's hard to follow. But I would recommend signing up for the CFPB's website and getting those alerts if you haven't already. TRID issues. So for those of you who are doing consumer compliance work and trying to make sure that your documents comply, these are some of the issues that a number of folks have identified. And this was a letter to the CFPB from the Association of Mortgage Investors. And I read another statistic that 90% of all loans have a TRID violation. And that's important in a few seconds, but that's insane. 90% have some type of problem. So these are the most common areas of issues. Just form problems, the lender's name and the address is missing from the disclosure. late delivery of the loan estimate. So for those of you who don't know, there's specific time frames when the documents have to be delivered, and that is an issue. The product type description at the top of the page of the loan estimate, whether it's fixed or variable, that's wrong. The estimated taxes and insurance are incomplete or incorrect because you've got to estimate those. That's been an issue in a lot of these reviews. The other considerations table is incomplete, and that's on page 3. And so for those of you who don't deal with this every day, you have to check a box. Is this loan assumable? Which is sometimes a hard thing to answer. So those boxes are not checked when needed. There's computation errors. For people who do this, you know what I'm talking about, so I'll go through this pretty quickly. The estimated closing costs on page 1 of the loan estimate and the total closing costs are not calculated in the same way. That's been a recurring problem. And then the escrow payments are not completely calculated. The CFPB's webinar from Tuesday had a lot of information about property taxes and escrow insurance. So if that's something that you're struggling with, I would absolutely listen to that. Same thing for the closing disclosures. Again, missing information at the top of the page. And the closing disclosure is what we all used to call the HUD-1. It's got more information on it, but it's a little bit similar. The estimated taxes and insurance are incomplete or inaccurate. Again, computation errors. The closing cost details on the form don't match. So when you go through, that's really your old HUD-1 breakout. So those don't add up. The loan cost includes fees that weren't previously disclosed on that early disclosure. That's a problem. Again, check the boxes on the disclosures are not completely filled out. So if there's an assumption, if there are escrow payments or partial payments, sometimes those boxes are just missed. Closing time frames, now there's specific times about when you can close, and there's not compliance there. And then a big error that they saw is the calculating the cash to close. There's a spot that says, have these figures changed? If it says yes, there's usually a problem. So that's something to think about when you all are reviewing your loans and then talking to your audit committee. So these are the problems that people are seeing with TRID right now in implementation, and this has become an issue because we don't know what to do with these errors, and there's a little bit of uncertainty within the rule. And the Association of Mortgage Investors, they have a big concern with this as well because there can be assignee liability. So do we keep these loans or do we send them back to the originator for a repurchase? And the problem is we don't know where these rules really come from. So there are 2 different statutes that we're dealing with. There's the Real Estate Settlement Procedures Act, or RESPA, and then there's the Truth in Lending Act. And the CFPB just combined everything. They did a 1,000-page rule and just lumped it all together. And it's unclear if a particular provision or requirement is based in RESPA or if it's based in TILA. So there's that uncertainty there, and there is a difference when it comes to liability. So RESPA, there really is, for the most part, in these disclosure issues, no private right of action and no liability from a statutory perspective. We'll talk about examinations in a minute. So if you get sued, or if we used to handle cases all the time for HUD-1, sue me all day long for that because there's no private right of action, and we've got good case law in the Sixth Circuit that says no damages under RESPA. TILA, whole nother area. I mean, TILA has rescission rights for borrowers, there's statutory damages, there's attorney's fees. So because we don't know where this violation comes from, it's hard to say, well, what do we do with it? Can we just move it on through, or is this a problem and should we send it back? Director Cordray sent a letter to the Mortgage Bankers Association in December of 2015, and when you read the letter, he said, really, this is no big problem, guys. This is not a big deal. I think it's a big deal. He, said the prior fundamental principles of liability under TILA or RESPA still apply. Well, it's hard to, we know what the fundamental principles are, but we just don't know how to really apply those. He said, if you got a TILA violation, I read this to say you can only be responsible for statutory damages and class action damages. Well, that's a big deal, and I felt like he kind of glossed over that, especially when you get into litigation, when you talk about class action damages over your disclosures. So he did clarify the loan estimate. That's really RESPA. You can't get in trouble for that, but you can get in trouble for the closing disclosure, which really arises under TILA. He emphasized the cure provisions in these rules. So if you have a violation, you can fix it by paying the borrower some money. I think it's within 60 days. And if it's a clerical error, you can send new documents. I don't know how helpful that is, but Director Cordray thought it was. And he did say that the TILA damages don't apply to some of the new Dodd-Frank disclosures, like the total cash to close and the total interest percentage. So there is some clarity there. I don't think that it helps us sleep at night. And my thought is this was just a letter to the Mortgage Bankers Association, which is great, but how are you going to explain this to a judge? And I was thinking about it last night, and how am I going to explain this to a judge in Eastern Kentucky who's going to look at me like I have two heads and say, genuine issue of material fact, off to a jury trial? I mean, that's exactly what's going to happen. So we do need a little bit more clarity, not only in the TRID rule, but maybe some type of official letter or directive from the CFPB that talks about what the liability is, at least from a consumer standpoint, when we have these violations, because they're clearly happening if 90% of all loans have a problem. As far as your examinations, you still have those issues, and Director Cordray said that examiners will be squarely focused on whether companies have made a good effort to comply with the rules, and so that examinations will be corrective and diagnostic rather than punitive, at least for a short period of time. So I wrote on my comments here, this is straight from the horse's mouth, which is my Keeneland pun, I guess. But we'll see what happens. We'll try to update again on next year and see if we have any enforcement actions that deal with TRID issues. We thought we'd talk about some other things that may just have general applicability to some of the lenders in the room.
So I'm going to talk briefly about the recent Supreme Court opinion, and I use the word opinion very lightly, and I'll explain why in just a moment. In Hawkins versus Community Bank of Raymore, this is a case that arose out of the 8th Circuit Court of Appeals. So I'm sure most of the people in the room know, but just some background. ECOA is the Equal Credit Opportunity Act, and it prohibits discrimination specifically against applicants, and that's an important term for purposes of this case. With respect to any aspect of a credit transaction on the basis of race, color, religion, national origin, sex, age, or marital status. And marital status is specifically what was at issue here. So Valerie Hawkins and Janice Patterson are the wives, and this all arose out of Missouri. They're the wives of two real estate developers in the state of Missouri who were planning to develop a subdivision. These gentlemen were the principals of the company. They obtained 4 different commercial loans to get this property off the ground in Missouri, and this was in 2008. And the total principal amounts of the loan were upwards of $2 million. So this is in 2008. At the time of the loan closing, the Community Bank of Raymore, they had Mrs. Hawkins and Mrs. Patterson, who were not involved in the company, who was the actual loan applicant. They had them guarantee the loans, and the question was, what was the basis of that guarantee? And their argument that I'll touch on here in just a second is that the only reason they were asked to guarantee the loan was because of their marital status to the principals of PHC Development, the two gentlemen, Mr. Hawkins and Mr. Patterson. So, of course, wouldn't probably get to the Supreme Court if there wasn't some issue that arose. So the loans went into default in 2012. The Community Bank of Raymore then accelerates the payment. The full $2 million is due and owing, plus interest, of course, and they demand payment, obviously from the principals, from the entity itself, PHC Development, but then also Mrs. Patterson and Mrs. Hawkins, pursuant to their guarantees that they had given at the time of the loan closings. So the issue that arises is that under ECOA, Ms. Patterson and Ms. Hawkins say, well, the only reason you had me back this loan is because I'm the spouse of of the developers in this case, and it's their company, and so you had me sign this spousal guarantee as a result of my marital status. That's discrimination against me, right? And so they argue that they should not only have those guarantees invalidated, but also that they're entitled to damages under the Equal Credit Opportunity Act. So this case arose from federal district court in the state of Missouri. The Community Bank of Raymore moved for summary judgment at the trial court level, and they ended up getting summary judgment in favor of the bank as to dismissing the claims from Ms. Hawkins and from Ms. Patterson, and their claims were dismissed, and the bank was entitled to enforce their guarantee against both of the guarantors, the wives in this case. So this goes up on appeal to the 8th Circuit Court of Appeals. And 8th Circuit Court of Appeals, I had to double check myself. We're talking about Arkansas, Iowa, Minnesota, Missouri, Nebraska, South Dakota, and North Dakota. So this went up to the 8th Circuit Court of Appeals, and the guarantors in this case, they say, well, ACOA does not specifically exclude me from the definition of loan applicant. I mean, I'm a guarantor. Arguably, I could be an applicant under the definition of Equal Credit Opportunity Act. And they also say that not only am I arguably an applicant, or am I an applicant, but I also can rely on the Federal Reserve's regulatory enforcement regulations under Reg B, and said, which specifically include an applicant to include a guarantor. And so, pretty strong argument, right? They're relying on the specific body that regulates this space, saying that this regulatory body says that a guarantor is by definition an applicant under ACOA. So in response, the bank says, well, that's fine, but that's the regulatory body. We're looking at the statutory language here, and applicant means what it says. Applicant is the loan applicant. In this case, it's PHC Development. It's not Mrs. Patterson and Mrs. Hawkins, or even Mr. Patterson and Mr. Hawkins, who are not the actual applicants on the face of the loan application. And then they say, as a result of that plain language, that the Federal Reserve's interpretive regulations are impermissible, and there's no reason to even look to that interpretive regulation, because you don't have to get there if you say that there's no ambiguity as to the statutory language. So all these arguments were made before the 8th Circuit Court of Appeals, and the 8th Circuit Court of Appeals ended up affirming the federal district court ruling in the state of Missouri, and they rule in favor of the bank on all grounds. And they say specifically that a guarantor is not an applicant under ACOA, using the same analysis I was just talking about in support of their arguments, that applicant means what applicant means. And that, which I don't know. The decision there, it turns on the Chevron analysis, which you may be familiar with, where basically if there's not ambiguity or an unreasonable application of the plain language, then you don't have to defer to the regulatory body. And so in this case, the 8th Circuit Court of Appeals says we're not going to give any deference to the Federal Reserve's interpretive guidance. And so, the Bank of Raymore is happy, except for the fact that Ms. Patterson and Ms. Hawkins go ahead and move for a writ of cert up to the U.S. Supreme Court, and this was in March of 2015. You can take it. So oral arguments were held on this case, and really the same arguments on both sides that I already laid out. Oral arguments was held in October 2015. Does anyone want to tell me what happened in February 2016 that affected the U.S. Supreme Court? Yeah, so Antonin Scalia, long-time Supreme Court justice, passed away, and everyone's saying, well, now we have this potential for a circuit, or not for a circuit split, but for a split of the court, an even court decision where we're going to have, the whole point of these cases is to have circuit splits decided when there's cases that are going in both directions on any number of issues, and in this case we have that specifically because we have the Sixth Circuit, who specifically says that the Reg B guidance controls, and that an applicant could include a guarantor. And then you have this case in the Eighth Circuit saying that the exact opposite, basically. And so Justice Scalia passes on February 13th, 2016, and then I've included the entire opinion of the U.S. Supreme Court on that screen. It's a per curiam opinion, meaning the full court joins in. We do know that there were four justices on both sides. We don't know who those justices were. We don't know. I mean, you can make some reasonable guesses, I suppose. So what this means is that the Eighth Circuit decision for the states that I discussed, the 7 states that are within the Eighth Circuit, that law is upheld as to those 8 states, but the circuit split remains as to every other state out there. So basically, this issue is completely unresolved as to the rest of the states of the United States. So we're going to continue to have a circuit split. Basically, the Supreme Court's rubber stamping and affirming the judgment of the U.S. Supreme Court as to the Eighth Circuit's decision, and so what this means is that the Sixth Circuit has completely different law. And so, basically the purpose of taking this up on appeal all the way up to the U.S. Supreme Court, we didn't get the resolution that we wanted. And this was the first case where, the failure to have a new justice nominated and appointed through the process had a substantive effect on your all's business practices, perhaps, and that now the circuit split continues to remain out there, and the only people who now know have clarity on the law is the Eighth Circuit. And so I think from a takeaway standpoint, I think the big thing is this leaves the door open to courts continuing to apply applicant under ACOA to mean a guarantor, unless you're within the Eighth Circuit, and I don't know if there's anyone in the Eighth Circuit here. There is precedent in the Sixth Circuit, as I mentioned, that completely goes the other direction in terms of determining who is an applicant under ACOA, and says that a guarantor can be, and it's RLBB Acquisition versus Bridge Mill Commons. Sixth Circuit case states that the controlling guidance or the guidance from the Federal Reserve is controlling, and like I said, cuts against the Eighth Circuit's decision. And I think for you all in the room who do commercial lending, I think all this means is that you all have to be extra cautious and careful about why you're obtaining a spousal guarantee. If you're obtaining a spousal guarantee because of marital status in and of itself, you're going to run into potential liability. And so from a practical standpoint, lenders need to be deliberate about retaining clear documentation about the purpose of any spousal guarantee, and just make sure that you're documenting and having these discussions at the front end. I guess there is clear guidance in the Eighth Circuit, but unfortunately, the reality came true that a 4-4 split has happened and may continue to happen until there's the vacancies filled on the U.S. Supreme Court. But for you all, just be aware of this decision and how it may affect your business practices going forward in the context of ACOA and guarantors for commercial loans. And I'm happy to discuss any ramifications. I want to keep us on track so Katie can close us out.
One thing I have been really interested in this year, and I think it's from talking to a lot of you all, is vendor management. So I have a lot of people come up to me and say, what is vendor management? What are we supposed to be doing? And I think this is something that's really hard to implement in your bank. And so I went through some of the guidance that we've received from the CFPB and the OCC and the Federal Reserve Board about what you need to be doing as far as vendor management. And I did a little top 10 list. No particular order, and then I have some slides that will talk about some of these in particular. So I'll go through those pretty quickly and see if we have any questions so we can stay on time. These are all in your materials, so I won't talk about all 10. I'll just talk about the ones that I've identified with a little bit more information. Let's back up a second. What is vendor management? It's any time that you have a contractual relationship or it should be a contractual relationship, because I think that's part of the issue. Sometimes there are not contracts in writing with some of these issues, but anytime you have a relationship with someone else to perform business functions or activities, that's vendor management, and these are the things that you need to be doing. Some of the typical areas where we see vendor issues or vendor relationships are IT, core bank processing, accounting, appraisal management, human resources, internal audit, sales. Sometimes you'll see collections, repossessions, marketing, loan reviews, loan servicing, data security, and whatnot. So these are the things you should be doing to make sure your institution has. And if this is helpful, let me know, because I thought about maybe doing, an e-alert every month talking about these particular things in a little bit more detail. Number one, you've got to involve the board. They have to be a part of this. We need to have a written vendor management program. And the board has the ultimate responsibility to make sure that the program is operated in a safe and sound manner. Also, the bank has an obligation to make sure that its service providers and its vendors are complying with applicable law. There have been a few CFPB enforcement orders and I think an FTC enforcement order against a financial institution based on what its service providers were doing. Sprint was one where its service provider was adding charges to bills, Capital One, and the way that some of its servicing practices. So the bank itself or the financial institution was fined significantly based on what their vendors are doing. The CFPB requires that the program you have be tailored in size and complexity of the company, the regulations that you have at issue, and the risk. And we'll talk about that in a minute as well. And then your senior management, they have to be on board as well. There needs to be clear individuals who are responsible for not only making sure that the vendor management program is executed throughout the bank, but following up and then reporting back to the board. I put risk. My top 10 said you've got to evaluate the level of risk, but if you read through some of the FRB opinion, the OCC directives on vendor management, I think risk is in every sentence, every single sentence. It's really important when you're talking about vendor management to sit down and identify what type of risk you're looking at, and that will help you understand how much of a detailed program do you actually have to have. So if it's a service that has a substantial impact on your company, you need to pay attention to it. You need to be very clear and intentional about your program. Another way to think about this is that that vendor goes away or has an issue, how are you going to be impacted? Are you going to have to shut down operations, or do you have a backup person in mind? What's going to happen? What consumer products are involved? That's always going to be an issue in vendor management. Is it a new service? Again, is it your critical activities like your payment processing and whatnot? Are there privacy concerns? If so, that's a heightened level of risk that you need to consider when you are drafting your vendor management policies. Are there compliance issues? And then when you think about risk, also think about how can you best protect against that risk. Is it sending it out to a third party, or can you actually do this in-house? I mean, we can't do everything as a bank, and so I think you have to think about, can I do this? Do I have people here? Do I have the staff, or is this something that's got to go someplace else? Due diligence for each vendor. When you're deciding on how to choose a vendor, you have to investigate that particular vendor. You've got to review them. If you enter into a contract with them, you've got to continue to monitor them, investigate them, and then you've got to repeat that process somewhat regularly. One thing that we recommend is when you are starting this process now with your vendors and you're maybe starting a vendor management program, call your vendors up and say, hey, we're going to have to renegotiate our contract. We're going to ask for a lot more than we normally do, and this is why, because we're getting pressure. I don't know if some of the vendors understand. They should. If they're doing financial service products, they know what's going on, but it's good to always call your vendors. As Liz mentioned, we are a vendor, and so we have to go through these surveys every year to make sure that we are in compliance with the really financial regulations, that we've got data security procedures in place, that our servers are lifted off the floor in certain areas. So call your vendor, say, hey, this is what's going on, let's talk about it, we're going to have some changes. When you're doing this investigation, You can rely on third-party audits of the vendor, but make sure they're good audits. Think about who prepared them, the scope and purpose of that particular audit, the depth of the review, and how comprehensive it is. Other things to consider when you are doing due diligence for your vendors: their business background. Who are the company principals? If they've only been around for a year, that might be a problem. What kind of employee training do they have? Do they make sure that their staff is trained? A law firm in Georgia has had a little issue with the CFPB in the last year, the Hannah law firm, and they only had, at one point, I think 8 attorneys, but they had thousands of cases. That's the kind of questions you should be asking. How many people do you have who are going to be doing our work? What are their business strategy? Do they want to kind of stay in this particular area, or are they trying to grow? Do they have the finances to do that? How key is your bank's business to this company? How much they rely on you? And insurance coverage is also an issue. Do they utilize subcontractors, and where are their subcontractors located? If you have a foreign-based service provider, that should set off a lot of red flags for you. Just to think about, that particular entity that may be located internationally, and is there any risk there for social, economic, or political pressures that could impact your bank? You've got to have frequent oversight and monitoring, on-site visits for your big providers that have very risk inherent services that they're providing to you. I know for some law firms, foreclosure firms, the big servicers are coming out and visiting them at least once a year to make sure that their staff is in compliance with regulations. When you're doing this oversight and monitoring, if something doesn't smell right, you should follow up. It shouldn't be just, oh, this is someone else's responsibility, or I'm too busy. You need to see what's going on so that you don't put your institution at risk, and you have to take appropriate action if there's a problem. Really, your focus should be on what is the risk to the business, but also what is the risk to the consumer in these areas. Your contract review. You've got to have a qualified person review the contracts, and this is difficult because it's expensive. I mean, you don't want to send your contract out to your outside law firm every single time, especially if you've got thousands of vendors. But then having someone on staff to do that who's qualified can be expensive as well. Whoever's reviewing your contracts in-house, make sure that they understand what the product is. If they don't understand how it's going to work, they may not be able to see some of the red flags that might be there. Look at performance standards in contracts, the costs and compensation that your vendor may be receiving, the scope of services, what does the contract say about what they're going to be doing. Software is a big issue. Whether you're going to have a license, security, tech support. We have another client right now who's not a financial institution, but they're in a dispute with the company that provides their software, and they're essentially being held hostage because they can't get the updates they need until they get this payment dispute worked out. You don't want to litigate, and that's really a bad situation to be in. You need to think about, limits on liability. A lot of contracts that we see will say, oh, well, our limits on liability are what you pay us over this year. Well, if you get sued or if you get a big enforcement action, that's not going to cover it. And then what happens in those situations? Dispute resolution, are you going to mediate? Are you going to do arbitration? If you're going to do those, what do your clauses look like? That's always an issue, making sure that you've got venue and choice of law protections in those contracts that benefit you if you can. Customer complaints, who's going to handle those, who's going to respond, who's going to follow up. If you've got dual employees, it's going to work for both companies. Sometimes that happens. How does that work? And then your right to audit. Customer complaints is another thing that I had on my top 10 list. We talked about this last year. If you're a bank, you should be checking the CFPB's website to see if there is a customer complaint about your shop. I try to check it for some of my clients on a regular basis, small local clients. You need to be looking at those complaints. You probably get notice from the CFPB anyway that you're getting them, but you need to see what the problems are. Is there a history? Is it the same collection practice that you have? Should you change this? I think customer complaints are a great way to figure out what's going on and maybe fix it if you've got issues, and it's also a great way for regulators to figure out where your problems are as well. So you should look at your own customer complaints, and if you've got vendors, you should look at their customer complaints as well through the due diligence process and the monitoring process. What's next? Who knows? I think Fair Debt Collection Practices Act will be a very big topic this year. We've been waiting for the CFPB to issue a rule for a long time. They may get to it. I think that will change the way potentially that we do business as a firm for banks, but I also think creditors who now currently have exemptions under the rule, I think that they may be impacted as well if the CFPB gets their way. Fair credit reporting is always a problem, making sure that you've got written policies and procedures on your credit reporting and your disputes. So if you get a dispute from a customer, how do you handle that, and do you handle it as required by the statute? Military lending, always a problem. CFPB loves military members, so you got to make sure that you're doing everything there as far as SCRA and UDAP issues. And that's really it. I mean, we've been very busy here in Kentucky. There are at least 2 guys in the Louisville area who are representing borrowers, and they want each to have a 6 to 10 attorney place just suing banks and auto dealers. And they're doing it. They're aggressive. They're taking these cases to trial, and we expect that to continue.